Yes, good morning. James DeSimone on behalf of plaintiff and appellant Daniel Garza. May it please the court, I'd like to reserve 3 minutes for rebuttal.
Counsel, please be reminded that the time shown on the clock is your total time remaining.
Understood, Your Honor. I think when you look at the totality of the record here, it's clear that Daniel Garza was denied his right to a fair trial in the Monell portion of this case. And there are a number of ways in which he was denied a fair trial based on the exclusion of relevant evidence. The jury was deprived of the key evidence it needed to decide whether the city of Los Angeles, who is the defendant here, not Chief Beck, the city of Los Angeles, made the conscious affirmative choice to promote Officer Cardona within 3 weeks of a jury verdict against him, finding constitutional violations based on him acting maliciously when he battered and essentially tortured Daniel Garza when he was subdued and he applied a painful wrist lock. And I'd like to go through each and every one of those pieces of evidence that was excluded. I think any one of those pieces of evidence that was excluded warrant reversal here. And when you put them totally, it's clear that we were just deprived of a fair trial in proving our Monell allegations. The first piece of evidence that was excluded that was prejudicial was what I'll call the ratification letter. It's found in the excerpts of record 805. It's a letter on Chief Beck's letterhead. There's a video of this incident, a large portion of the incident after Mr. Garza is subdued. And in that letter on 805, under Chief Beck's letterhead, it says, the act you've complained of occurred, but we find this to be lawful, justified, lawful, and proper. And so this is relevant to Chief Beck as the final policymaker approving the conduct and the basis for it. What do we have to prove in order to prove ratification? We have to prove that the city of Los Angeles approved the act and the basis for it. Well, if we have a piece of evidence, a letter that goes out on Chief Beck's letterhead in which they say, we've reviewed the act, we've witnessed the conduct, and we say that it's lawful, justified, and proper, what more compelling piece of evidence could there be for ratification? Yet the judge in ER 20, in the excerpt of record on page 20, in a footnote, just says, I'm excluding the letter without any legal basis for the exclusion. Now, it is true that previously he had decided against us on summary judgment, that the letter alone could not constitute ratification. He said without additional evidence. And of course, here we do have additional evidence that you have an officer who was promoted to sergeant within 3 weeks of being found liable for serious constitutional violations and for having acted maliciously against Daniel Garza.
But Chief Beck testified, and he was subject to whatever questioning you wanted to ask him about what he knew, when he knew it, and on what basis he made whatever decisions he made, correct?
My questioning was limited to what he subjectively knew. And this is where I think the court erred as a matter of law, Your Honor, because the case law is clear that under the Hammond versus County of Madera case, for instance, a 1988 Ninth Circuit case, which is a ratification case, that it is constructive knowledge can be used. It's an objective standard. So what the court did was, acting from the premise that the only evidence that was relevant was what Chief Beck would subjectively admit that he knew, and excluding everything else, the court made reversible errors in the following ways. One, the clear case law based on Hammond versus County of Los Angeles that holds that municipal decision makers may not insulate themselves from liability by attempting to delegate themselves out of responsibility. And in fact, in the Hammond case decided as a matter of law that the defendants had ratified that conduct. And it also held that the board, the defendant there, the board, was charged with knowledge of the laws. So this is how unfair it was, Your Honor. And of course, as Your Honor knows from reviewing the record, I was the trial lawyer. So every time I would cross-examine Chief Beck would fall back on basically parroting a incorrect analysis of the law, that this was out of statute, his hands were tied, and he could not interfere with Officer Cardona's promotion because he was informed that it was out of statute. Now, he hadn't testified that into deposition. This was something that was just sprung at us at trial. So in terms of Your Honor's point, well, you were given the opportunity to cross-examine him, as we've made clear in our papers, I had impeachment evidence. I had impeachment evidence that he made the deliberate decision not to reopen this investigation. And inexplicably, the trial judge would not allow me to read that impeachment evidence into the record. So on the very point that we have to prove that Chief Beck made a deliberate decision not to reopen this investigation, he was allowed to bring up a new defense that he hadn't testified to at trial. And I was not allowed to impeach him on it. And if you look at the record, every time I would ask him a question about these items, and I can basically point you out to the pages in the record, he would fall back on, well, this is out of statute. On page 196, it doesn't toll the statute. It doesn't change the statute. On excerpt 215, it is certainly past statute. Excerpt 217, he asserts that it is past statute. In other words, he was saying, when I say he was saying it's past statute, he was saying that because of the statute of limitations, he could not use this conduct of Officer Cardona in order to deprive him of a promotion. But that is incorrect as a matter of law. Under Government Code Section 3304, subsection F, if there is pending civil litigation that involves a public safety officer and his threat to the public, that civil case itself tolls the statute of limitations. So it was within the statute of limitations. And so the other
but even if he was mistaken on that point, isn't the operative question what he knew, or on what basis he made his decision?
No, Your Honor, it's not what Chief Beck knew. That's contrary to the long list of both Ninth Circuit and Supreme Court decisions that says that one, this constructive knowledge can be used against the policymaker. So the fact that he should have had constructive knowledge. Two, that's an objective standard, not a subjective standard. And three, that you cannot delegate responsibility and then claiming I didn't know. So all of those doctrines that, if you look at the Hammond case, and again, Castro versus City of Los Angeles, Ninth Circuit 2016 case, it quotes the Supreme Court that they strongly suggest that the deliberate indifference standard for municipalities is always an objective inquiry. So the focus on what Chief Beck subjectively knew was an error as a matter of law, and all of the evidentiary rulings that flowed from that assumption ended up prejudicing plaintiff's case. And then when you take into consideration what actually occurred here, that you have a city attorney who is the agent of the City of Los Angeles. Now, I would bring Your Honor back to the Kembauer versus City of Cincinnati case, in which the policymaker who tried to delegate, saying, well, I was following legal advice of the district attorney in that case. They said, no, you can't claim that you're just following legal advice when the legal advice is wrong. This was, Kembauer was a case in which they ended up breaking into someone who hadn't complied with a warrant, and it was clearly contrary to the law. No, you broke the law. Now, in this case, we have the city attorney as the agent of the City of Los Angeles that actually argued that Officer Cardona had acted with malice when he performed that conduct against Daniel Garza. And then you have the doctrines of judicial estoppel that we've briefed and that should have been used here, that the city took the position that Daniel Garza acted with malice, and then they were allowed to retreat from that position at trial. In fact, it was so brazen, Your Honor, that when the city attorney argued in her closing argument, I have great respect for the city attorney's office in Los Angeles, but she actually argued that there was no evidence here that you had a supervisor, Commander Prokop, who had testified in that first trial, that when he viewed that video, that officers' conduct was unreasonable and unprofessional. And you have the fact here that we were able to get into evidence his response to interrogatories, which said, I reviewed the internal investigation. And then another major error here was that we couldn't get into evidence anything about the first trial. So how is a jury supposed to make a decision as to whether a promotion ratifies prior misconduct without context about what that prior misconduct was? We weren't allowed to play the video. We weren't allowed to offer Officer Prokop's testimony, which was videotaped. He testified by videotape deposition in the first trial that this was objectively unreasonable, which is the standard. And we weren't allowed to introduce the testimony of an eyewitness. It said that Officer Cardona had battered Mr. Garza over 20 times while Mr. Garza was just protecting himself and not fighting back. The jury was not given any of that evidence. I could ask Chief Beck, did you know about it? Chief Beck says, no, I didn't know about it. And then I had no evidence. And the city attorney in her closing argument, actually, if you review it, I argued that you didn't hear any evidence of the commander saying that this was unreasonable. You just heard Mr. DeSimone asking about it. You just heard Daniel Garza's mother saying that's what happened. So they were able to retreat from the position. And the concept of judicial estoppel just does not allow for that, because they were able to take advantage of what they did in the first instance, in the first trial, to avoid compensating Mr. Garza. So I'm not hearing you, Judge Rawlinson. I still can't hear.
I muted myself. So Chief Beck signed the actual order that promoted Officer Cardona?
That's correct. Chief Beck signed the order.
So what would have happened if Chief Beck had refused or declined to sign the order?
What would have happened is there would have been a reopening of the investigation, and the city of Los Angeles would have been given the opportunity to review all the evidence that the city attorney had in making its determination strategy-wise to say that Officer Cardona acted maliciously, and I think the promotion would have been declined.
So is it your position that Chief Beck had the authority to stop the promotion by declining to sign the order?
He absolutely had that authority under Government Code 3304 and relied on a misstatement of the law. And again, to allow Chief Beck to subjectively parrot a misstatement of the law instead of allowing the objective evidence and what he constructively knew. And we were denied, we submitted jury instructions on agency. And the jury instructions basically said that the city attorney is an agent and you should have constructive knowledge of all those facts that the city attorney had. And that is what the law is. And there was no reason not to apply those bedrock concepts of law in terms of agency here. And I see I have 1:30 left. And if there's no more questions, I will defer.
All right, thank you, counsel. Rebuttal.
Yes, thank you very much, Your Honors. In terms of the focus of the last question, I think it is very important that it was Chief Beck that signed off on this promotion. And I think it's absurd to say that he couldn't parse this out, that he would have had to reject everyone. He could have rejected Cardona. But there's another big piece of what Chief Beck did and essentially didn't do that shows that the city of Los Angeles is liable. He could have reopened an investigation into Cardona after the jury's verdict to see whether or not the internal affairs investigation had properly adjudicated that this was lawful justice, justified or proper, or whether the jury...
Counsel, why did he need to do that? Because there's nothing in the record that I'm seeing that Chief Beck really disputed the verdict in the first case, or was, going out there saying that the verdict was wrong and the jury got this totally wrong and the internal affairs got this right. That's not in the record. So why do we need to reinvestigate it? He wasn't fighting against the first verdict. He was going forward understanding what had happened. Well,
he needed to do it because he is the policymaker and he has the ability to promote Officer Cardona within 3 weeks of this verdict. And the message it sends, why does he need to do it? Because we're talking about policies here that basically traditionally in Monell liability have been the type of policies that chief of police make. Do they tolerate or condone excessive force? You have a very public verdict. It was in the LA Times, it was on television, and you are promoting an officer to sergeant within 3 weeks. The message that that sends as the chief of police to the rank and file officers is that excessive force is tolerated and condoned. In fact, you could be promoted within 3 weeks of being found there. The other reason he needed to do that is because you have the city attorney. Now, the earlier questions to Michael Walsh were what position did the city take here? Well, the course and scope of employment was decided against the city. The jury found that Officer Cardona was acting in the course and scope of employment. But if you look at excerpts of record, pages 590 to 592, which is the city attorney's closing argument, and he talks about how Officer Cardona's conduct was despicable. And he said that if it was so despicable that afternoon, it has to be held to be malicious, that he acted in willful and knowing disregard of Mr. Garza's right to safety. So that knowledge of the city attorney, that Officer Cardona acted with that level of maliciousness, has to be imputed to Chief Beck under the law. That's where the jury instructions of agency that we put in. Again, it's the city of Los Angeles that's the defendant. And if I could just point your honors to the case of Medeiros, which we have cited, Mendiola Martinez versus Arpaio, 836 F3rd 1239. Again, a Ninth Circuit 2016 case where it says it's not the subjective standard. It's an objective standard when you're looking at a city entity. And again, the famed Sheriff Joe Arpaio was the defendant in that case. They said he was a redundant defendant. And they made the county the defendant in this particular case. And they said, therefore, you don't look at what's in Arpaio's subjective knowledge. You look at objectively what the county knew. And in the same way, objectively, the city of Los Angeles knew that Officer Cardona acted maliciously when he violated someone's rights. And the city of Los Angeles promoted that man within 3 weeks of that verdict. And
that issue was presented to the jury, right? I mean, we're not here on summary judgment or anything like that. We're here post the jury. So the jury got to hear what the result of that earlier trial was, got to hear what Chief Beck did and the signing of the promotion. And they made a call and said, we don't think this is ratification. We think it's something else. Why should we disturb that? I mean, they heard both sides of this.
No, the reason why it should be remanded is because the jury was deprived of all of the relevant evidence. They were deprived of the letter. They were deprived of Procop, a commander saying that this conduct was unreasonable. They were deprived of an eyewitness. They were deprived of the video itself. I mean, how do you show whether or not the conduct is ratified unless you know what the actual conduct was? So while we were tiptoeing around the edges of some of the conduct, we were never able to introduce evidence. So while I would agree that normally a jury verdict, hey, I lose a jury verdict, it's the end of game. This is a case where that's not true because the jury didn't hear all the relevant evidence. There are two main purposes of Section 1983 litigation. One is deterrence, one is compensation. My client hasn't received a dime in compensation for the harm that is done to him because the officer declared bankruptcy. And you're not deterring this conduct if you're promoting an officer within weeks. And again, I fall back on Government Code 3304F. This is not a matter of interpretation, whether or not the city of Los Angeles had the right to interfere with this promotion. They had the absolute right because the statute is told when those lawsuits are filed. And that's in Government Code 3304F. And the Hammond case, and if all of the Supreme Court progeny says, those policymakers, they are imbued with knowledge of the law. They have to have knowledge of the law. And it was just profoundly unfair in this trial for Chief Beck at every turn when I tried to cross-examine and say, my hands were tied, I couldn't violate the law when he is misstating the law. the knowledge of the law, the knowledge of the city attorney, in terms of what the city attorney knew about the first trial, should have been imputed to Chief Beck. And again, it's the city of Los Angeles is the defendant. And what we have here is a really bad, dangerous result, because we have a situation where you have a person whose civil rights were violated and he's not compensated. But more importantly, you have, in this time where we want police accountability, you have a department which has provided absolutely no accountability here. You have a department which said that we condone the use of excessive force. We can go so far to have one of our representatives, a city attorney, argue in court that this officer acted despicably and maliciously, and within 3 weeks promote that officer. Something is wrong there. Something is drastically wrong. And this court is the court that can right this wrong by reversing and remanding. And I would suggest a couple of things. One, it should be joint and several liability for the authorities that we've placed in there. And two, I think that this is so egregious that we should actually win this as a matter of law. We asked for a directed verdict. And I argued to Judge Wilson, they are arguing a point of law as an excuse for not interfering with this promotion that's contrary to the law, contrary to Government Code 3304. We should get a directed verdict. And the jury wasn't given that law in 3304. In other words, that wasn't a jury instruction that I could then tell the jury, this is the law that you have to follow, and that the law, that when Chief Beck said that the law was told, he's absolutely wrong, this is why. That wasn't a jury instruction that was given. Instead, the jury instruction that was given was actually, he added on to the Ninth Circuit ratification instruction in a way that was misleading, because it didn't apply to this situation. And I argued that to Judge Wilson as well. But basically, the last part of that ratification instruction said the failure to not approve a subordinate's decision. But this is not a subordinate's decision. This is where a policymaker made two key decisions. One, he promoted an officer within 3 weeks of the finding of misconduct. And two, he refused to reopen an investigation. And in closing, I know my time is up and well past up, but if you look at the excerpts of record 558, 559, and I asked him, you deliberately chose not to open up that process. And the predicate question was to open up an investigation. And this was in August, after he had heard Daniel Garza's mom, Angela De Jesus, at a commission meeting, tell him everything that had happened here. And his answer was, I did deliberately choose not to open up that process. But guess what? As you honors know, I wasn't able to read that impeachment evidence. It was inexplicable why I could not impeach Chief Beck on the very key point that he deliberately chose not to reopen an investigation. And that's reversible error right there. That did not allow a fair cross-examination.
All right, counsel, thank you. We understand your position. Thank you.